Check out carmarshal.com. The link is in the description. They help support us. Hey Charlotte County, this is Charlotte County COPWATCH. We are here to pick up the audio recording of the tyranny that they did to a guy that recorded just because he walked in the entrance here to record. They tried to put him in jail, and then they gave him a big fine, and we're here to get the recording of that. That will be on YouTube and by tonight. Are you going to court, man? Are you going to court? Are you busted?
No.
Okay, you busted somebody else. Very good. Yep. Thank you very much. Hey, can I give my card to you in case you know of any corruption?
What's that?
Can I give you my card?
For what?
I help out with COPWATCH. We fight police corruption here in Charlotte County.
Okay.
So if you ever hear of any stories, you get a lot of people getting up. There's a lot of stories of corruption going on right now.
Okay. Thank you.
Did you know Robert Tuck's story would have never came out if one of you guys wouldn't have sent that to me in the mail? That's sad, right?
It is.
Thank you.
It is.
Why didn't the sheriff charge him for perjury when he committed perjury?
I don't know.
Because he's married to a detective, and the detective would have to divorce him because she can't hang out with a criminal. That's sad, right? Come on. Are you going to run for sheriff?
What's that?
Can you run for sheriff?
I could if I wanted to.
Come on. Get a hold of me. My email's on there. Let's run on the Constitution and freedom.
State v. Ian McGuire, 1718-46M. You're having this transfer? Well, it's of record. It has to be of record because it's a...
I know.
Okay. Fine by me, I don't care. All right. We'll probably use these. Thank you. All right, we're here on an order show cause. Gentlemen, correct me if I'm wrong, there was an affidavit order show cause issued by Judge Alison Gurney, signed on September 29th. The attached affidavit, it was served on Mr. McGuire on about October 2nd, 2017. Case, Mr. McGuire, Mr. Shirley entered a notice of appearance on or about October 17th. Mr. Shirley was also representing Mr. McGuire in some unconnected criminal matters. Mr. Shirley has been the attorney in this case since at least October 23rd, when there was a stipulation for continuance filed. The defendant there was an arraignment on the order show cause, in which the order show cause and the affidavit was provided to the defense attorney. Actual reading of the entire affidavit and the order show cause was waived by Mr. Shirley. And then the case ultimately was set, I think it was reset one other time, but to today's date for the hearing on the order show cause. Procedurally, does that sound correct? State?
Yes, Your Honor. Scott Patterson, City Shirley.
Mr. Shirley?
It does.
All right. Any pretrial issues that we need to deal with?
Well, preliminary, I'm sorry, I'll wait for Mr.
The only thing that the state of pointed out is, I believe when we were last here in November, defense counsel noted that this really wasn't a factual dispute so much as it was a constitutionality dispute, and whether or not the addendum signed by Honorable Alison Gurney I'm sorry?
We'll see if he still has that position. I guess his position can change.
No, Judge.
That's what it was, and
No, I agree with you.
If it has changed, I don't know, but that was the what the issue was, and I don't know if that's still their position or not, but that was the original legal
Sure,
issue.
that's why I inquired. I wondered if there were any stipulations as to facts that the parties were going to engage in. It certainly seemed at the last hearing that that was going to be the case. I do not know. I'm just trying to see where we are as far as, because the state has the burden, obviously, of going forward and proving the order of cause.
No, Judge, I think it's quite clear and from the evidence and from supporting documents what the administrative order is, at least the addendum to the administrative order, in addition to the fact that Mr. McGuire had actually videotaped public officials I think the dispute as to whether or not it's in a public area or whether or not it can be protected by virtue of the administrative order. So it's more of a legal argument than it is a factual dispute. It's my understanding that Officer Palau was here to testify that he saw a video of that security area on my client's website. And we're not here to dispute that. But one of the things that concerns me, Judge, if I may, preliminarily, is the addendum to the 20th Judicial Circuit Administrative Order 2.18. On the second page,
Hold on. Let me catch up with you.
I'm sorry.
Around here somewhere. I was just reading it 2 seconds ago.
That's their copy, Your Honor.
Yeah, that'd be helpful, Mr. Patterson.
If I can get it back from you, that was intended to be part of my evidence. Should we?
Thank you. All right, go ahead, Mr. Sherwood.
On the second page, the next to last paragraph, which I think is the operative paragraph here. At no time may any person display or use any electronic device while in the security screening area of the ground floor of the Justice Center. I think we're all in agreement where that is downstairs. All devices capable of recording sounds or images, including cell phones, cameras, tablets, laptops, and body-worn cameras and electronic devices shall be turned off and not be maintained in any position from which the recording of images or sounds is typically performed. Here's the sentence that causes me some concern about today's proceeding. Failure to comply with this rule will subject the person to immediate removal from the Justice Center. Now, Mr. Patterson has cited Schmitter, SCHMIDTER versus State, which is, let's see if I can, 103 Southern 3rd 263 from the 5th District. In support of his position, the operative administrative order, which is cited on page 4 of the opinion, paragraph number 6, it states, anyone who is observed continuing to engage in such conduct as contemplated by this order, after receiving a copy of this order and being instructed to cease and to desist by law enforcement, may face indirect civil contempt of court proceedings. If found to be in contempt of court, penalties include confinement, fine, or both. I don't see that in our administrative order. So I don't believe that...
Before we go any further, let me get down factually what the parties are stipulating to factually. So, I mean, if there is a stipulation to all of the facts that are outlined in the affidavit of the order show cause, then we can get right to legal argument. If there are some factual issues that are stipulated to and are not stipulated to, then before we get to evidence, I believe that the court, or the state, because they have the burden, must go forward. Right now, there is no evidence that Mr. McGuire was actually even anywhere in the courthouse other than the affidavit, which at this point is not proof. So let's get to the issue of facts first. If we are stipulating to some facts, let's come up on the record with what is being stipulated to, and then we can handle either First Amendment overbroad or vagueness arguments at that time.
So before we discuss facts, respectfully, we've asked the court to invoke the rule. I don't know who Mr. Patterson intends to call to testify.
All right.
Other than Mr. Pilato.
All right, we'll go ahead and invoke the rule. Anyone who is subject to being testifying in this case, either for the prosecution or the defense, must step outside. All right. Pilato is leaving. All right.
I'm not aware if we are or not stipulating. I'm open to it since it appears as though the facts aren't in dispute, but we do not have a formal stipulation at this point in time. I'm prepared to go forward with the facts. If the defense wants to stipulate to the facts as outlined and we can list off some facts, that's great. We get down to the nuts and bolts of the legal argument. I'm open to that as well.
Trying to figure out where we are.
I'm not sure what facts he would like me to stipulate to.
All right,
my client,
State, you may proceed. Call your first witness.
David Call, Deputy Pilato.
Deputy Pilato, please.
Judge, Mr. Patterson has shown me 3 exhibits that he intends to introduce. We don't have any objection to those 3 exhibits.
Your Honor has one of my exhibits. Thank you.
Probably sitting on the desk. Yes, I do. All right, Deputy, you may have a seat. Before we proceed, is there a request to take judicial notice?
There was, Your Honor. The state filed a amended notice to request the court to take judicial notice of both the underlying Administrative Order 2.18 as well as the addendum to that. It was dated July 6th of 2017.
It says the defense regarding the state's request to take judicial notice. It's probably mandatory.
Oh, no objection, Your Honor.
All right, the court will take judicial notice of the Administrative 2.18 and the addendum there too. All right, Mr. Patterson, you may proceed.
Has the witness been sworn, Your Honor?
Yes.
Thank you, Your Honor. Afternoon, sir. Would you please state your name, spell your last name for the record?
Larry Pilato, Piloto.
Where and how are you currently employed?
I am a corporal employed by the Charlotte County Sheriff's Office assigned to court services security.
How long have you been with the Sheriff's Office?
21 years.
How long have you been working here in the courthouse?
2.5 years.
The courthouse that we're talking about, that's the one that we're currently sitting in right now, sir?
Yes.
Is that in Charlotte County, Florida?
Yes, it is.
Turn your attention to Friday, August the 25th of 2017. Were you working in your capacity as a law enforcement officer for the Charlotte County Sheriff's Office here in the Justice Center?
Yes, I was.
And where exactly in the Justice Center, strike that, on that date did you have occasion to have an encounter with Mr. Ian McGuire?
I did.
Do you see Ian McGuire here in the courtroom today?
Stipulate to identification.
All right. Identification has been stipulated too.
Sir, on August 25th, 2017, did you have an encounter with the defendant here in the courthouse?
Yes, I did.
And can you please tell us what exactly, if anything, occurred on that date between you and the defendant?
Mr. McGuire was in the business for whatever business he was doing. And I believe it was after 1 o'clock in the afternoon or so, between 1, 2, 3 o'clock. He came down to the lobby area and was exiting like the normal flow of traffic goes.
You say the lobby area, is that the area that includes the little maze entryway of with those, I don't know what they're called, the posts with the rope?
Right, yeah, he was exiting and then diverted on his way out and went towards the maze area towards where most people come in, the front entrance.
So there are the three entrances. There's the employee entrance on the south side, there's another entrance on the north side, and then there's the west side entrance of that lobby. Is that correct, sir?
Correct.
And what door was it that the defendant went to or diverted to, you said?
He went to the main entrance in the front of the building,
The main one for the public.
for the public, correct.
What, if anything, did you do at that point?
At that point, he turned around and started filming the lobby area, the security area that we have in place.
How do you know he was filming, or how did you know at that time he was filming?
I could see, I was at the other end of the lobby, and I could see him with his iPhone, you know.
Some sort of electronic device?
He was holding it in a manner that's consistent with videotaping.
And where in relation, so is he in the area where the photographs of the current judges here in the courthouse are? Is that the area?
In that general area, in that corner, that was the first area he went to, yes, where the pictures are.
Where were you standing, sir?
I was at the end of the lobby near the the clerk of the court's information desk.
Did you approach the defendant when you saw him recording?
Not immediately, no.
Did another deputy approach him first?
Yes, one of my deputies,
Was that Deputy Franco?
Deputy Franco, told him that no videotaping was permitted.
And at that time, sir, on the outside of those entrances, on the exterior of the building, are there signs, or were there signs that advised that recording was prohibited?
Yes, there is. And there was at that time.
At that time, sir, were you aware of the addendum to the 20th Judicial Circuit Administrative Order 2.18 that prohibited recording in that area, the security area in the lobby?
I was.
After Deputy Franco approached the defendant and advised the defendant that recording was prohibited, what did you do?
I saw what was happening, so I started walking. I went to my office to get a copy of the administrative order.
You want to see if we do this fine?
I'm going to show you what I previously shown defense counsel stage 3 for identification. Do you recognize that, sir?
Yes, I do.
Does that appear to be a true and accurate copy of the addendum to Administrative Order 2.18 that you retrieved from your office on August 25th of 2017?
Yes.
Move stage 3 for identification to evidence trial.
Any objection to Gualtieri?
No, sir.
Be admitted.
Oh, what exhibit was that?
3.
3, sir. What was your purpose for getting Stage 3, sir, or a copy of Stage 3?
I wanted to offer it and give it to Mr. McGuire. I wanted him to be able to read it so he can be informed of the order that was in place.
And the order that's in place, does that or did that order prohibit the recording through the use of electronic devices of the security area in the lobby of the Justice Center?
Best evidence ruled in. Document speaks for itself.
Sustained.
Sir, after you obtained the copy of the document, actually strike that.
Would you like him to read the document?
I think I'm going to get to that here in a couple minutes after a few more questions. Now, sir, you obtained the document. You went to give it to the defendant. Did you hand him a copy of said order?
I did.
Did you yourself read it to him, or did you give it to him, the defendant, to read?
I gave it to him to read.
Would you please read for us electronic devices defined on the first page under Rule 2.451, parens A.
Electronic devices defined. An electronic device is any device capable of making or transmitting still or moving photographs, video recordings, or images of any kind. Any device capable of creating, transmitting, or receiving text or data, and any device capable of receiving, transmitting, or recording sound. Electronic devices include, without limitation, film, cameras, digital cameras, video cameras, any other type of camera, cellular, telephones, tape recorders, digital voice recorders, and any type of audio recorders, laptop computers, personal digital assistants, or other similar technological devices with the ability to make or transmit video recordings, audio recordings, images, text, or data.
Sir, I also ask you, in stage 3 on the second page of it, the third paragraph, can you please read for us the definition of the security screening area of the ground floor of the Justice Center defined, please?
Security screenings areas of the ground floor of the Justice Center defined. The entire area open to the public from the ground floor exterior entrance and doors through and including the area adjacent to the elevators and the area beyond the elevators in the vicinity of the information desk and the entrance to the maintenance area, the stairwell entrance, and the law library.
When you first saw the defendant on the 25th of August, and I understand that's not the reason for the contempt, but when you first saw him on that day, was the defendant in or within that area that you just read?
Yes, he was in that area.
Use that for me for a second. Can you please read for us the second to last paragraph on the second page, sir, of stage 3?
At no time may any person display or use any electronic device while in the security screening area of the ground floor of the Justice Center. All devices capable of recording sounds or images, including cell phones, cameras, tablets, laptops, and body-worn cameras and electronic devices shall be turned off and not be maintained in any position from which the recording of images or sounds is typically performed. Failure to comply with this rule will subject the person to immediate removal from the Justice Center.
Sir, after your encounter on the 25th of August 2017 with the defendant, did you subsequently see a recording of the incident online on a website, Parents, so they call this freedom?
I did.
Stage 2. So I'm going to show you what I marked as stage 2 for identification. Are you able to recognize stage 2 for identification, sir?
Yes, I can.
How are you able to recognize that, sir?
My name, my initials, my payroll number is on it with the date that I signed it. That's my signature.
Did you have a chance to review stage 2 for identification prior to testifying here today?
I did.
And does stage 2 truly and accurately depict the encounter between the defendant, Deputy Franco, and yourself on August the 25th of 2017 here in the Justice Center in Charlotte County, Florida?
Yes, it does.
Move stage 2 for identification to evidence, Your Honor.
The objection of Gualtieri?
No, sir.
You admit it?
If I may publish, Your Honor.
Mr. Patterson, how are you publishing it?
I'm going to publish it on my laptop if you want to reposition yourself. I'm going to position it to the
Sure,
judge.
if you don't mind. Would that be all right, Judge?
Sure.
I just didn't know if it was feeding to the court.
It was not. You're able to see that from?
Not anymore, Mr. Patterson.
My apologies, Your Honor.
5-0 is a magic number.
Is that better, Your Honor? Deputy, if you could step down around, please. And while I have this stopped here, sir, is this the beginning of the encounter between Deputy Franco and the defendant, sir?
Yes, it is.
No recording? Where? Could you show me the sign? This is the Charlotte County Courthouse, right? Yes, it is. This is also the secured area. You guys have a nice day. Thank you.
You want a copy of the order? So now that
way you're informed.
Could you explain the order to me, buddy?
Well, you can read it, okay? Okay, you can have a copy.
Are you familiar with the First Amendment of the U.S.
You just want me to
Constitution?
be informed.
I want you to be informed. This is a public...
Sir, was that you handing a copy of State 3 to the defendant?
Yes.
But why didn't you read it to the defendant, sir? Sorry, why didn't you read State 3 to the defendant?
My intention at that point was to hand him a copy of the order, and he already had left the lobby. And so he can read it at his pleasure and be informed of the existing order. I wanted to make sure he knew that there was, besides us telling him that, there was an existing order, and I wanted to hand him the copy.
The area that we saw depicted in States 2, sir, that's an area within the recording prohibited zone of the addendum.
Yes, it is.
Turn your attention now to Friday, September 22nd of 2017. Were you also working as a law enforcement officer with the Charlotte County Sheriff's Office here at the Justice Center in Charlotte County, Florida?
I was.
And again, on that day, did you have an encounter with the defendant regarding recording in the prohibited area of the Justice Center?
I did.
Can you please tell us how it was you came to have an encounter with the defendant on that day?
Mr. McGuire was again in the Justice Center doing whatever business he was here for. And as he was exiting, I was at this time in the front main area of the lobby.
So that area where you were coming out the door in States 2 to hand the defendant a copy of States 3. So you're
up in the front.
By the photographs?
Correct.
Okay. And what, if anything, did you see the defendant do, sir?
I see Mr. McGuire come down into the lobby area and divert and walk towards the law library.
So the defendant came out of the staircase, sir?
Stairwell.
And where is the stairwell in relation to the information desk?
Right to the right of it, as you're looking at the information desk, it's just to the right of it in the corner.
And the elevator, sir, they're also in that area?
Yes, right in the general area.
So after you saw the defendant come down out of the stairwell, what, if anything, did you see the defendant do?
So he walked towards the law library, and I lost vision of him because I was in the front. And within moments, he emerged again and went to the information desk and turned around, and to me, it appeared he was videotaping.
And what led you to that conclusion, sir?
He had a camera attached to his hat, and he was facing us, just standing there facing us, facing our security area, and it was consistent with someone that was videotaping.
Where he was standing with the camera on his hat, is that in the vicinity of the information desk?
Yes, right there, right in front of it.
And the defendant was facing the security screening area?
Yes, towards where the monitors are, the magnetometer, the x-ray machine.
So in this instance, is he facing the back side of your security area?
Yes.
Did you approach the defendant on this date?
I did.
What, if anything, did you do when you approached the defendant?
I asked him, are you videotaping? And he wouldn't answer me. I think his exact words, I prefer not to answer that. And then, I went on to tell him that, videotaping was not permitted. And I reminded him that I had approximately a month prior handed him a copy of the order, which was still in effect.
And the order that you're talking about was Stage 3, the addendum to Administrative Order 2.18?
Yes.
Again, did you subsequently see a video of this second encounter with the defendant on that same website that we talked about prior?
I did.
Showing you what I marked as Stage 1 for identification. I say take a look at it. Do you recognize it? And if so, how?
I do. My initials, my signature, the date I signed it.
Have you had a chance to review Stage 1 for identification prior to testifying here today?
I did.
Is that a true and accurate depiction of the encounter on the 22nd day of September 2017 between you and the defendant in the Justice Center security lobby area? Is that a true and accurate report?
Yes.
We move Stage 1 for identification to evidence, move to publish.
Any objection or you?
No.
You admitted. You may publish.
In the area we're located in.
You may.
After your encounter with the defendant, well, this, saying that it did load up. It's trying to kill the time, and next thing you know, that's when it loads up.
Yeah, I feel like I'm being...
Sir, if you could step down, please, just briefly. Yes, sir.
Can you see Mr. Sherman?
I can.
And sir, the area that we're looking at here in the video to start out, there's looks like a bald eagle and a board dedicated to troops who are or have served here from Charlotte County. Where in relation to, is that in the Justice Center here in Charlotte County, Florida?
That is the area between the information desk and the law library.
So again, we're in the vicinity of that information desk.
Correct.
Stairwell would be to our right.
To the right of that eagle.
Elevators
To the front of it.
to be behind the perspective here.
Yes.
The area that the camera's focusing on now, is that the entrance to the stairwell?
Yes.
Information desk here on our left that we can see a corner of?
Correct.
And what we're looking at now, is that the back side of the security screening area? So
Yeah.
the X-ray screen, the monitors, the end of the security belt?
Your Honor, I know we're trying to speed this up, but I let a lot of leading go on. I'd prefer the officer to testify as to what he sees.
Overrule.
Sir, what area are we looking at?
Hold on, it's within the court's
That is the
discretion.
security-
Hold on, gentlemen. It's within the court's discretion to allow leading around. It's not, it's,
Okay.
overrule the objection.
Yes, sir.
Sir, what area are we looking at here on the video screen?
That is the security area of the ground floor lobby area, and it's on the beyond the magnetometer, X-rays by the elevators.
Again, within the area prohibited from being recorded by individuals in the Justice Center.
Yes.
Is that yourself approaching?
That's me starting to walk towards him.
I'm sorry?
Are you filming right now? Are you recording?
I prefer not to answer any questions.
Okay, all right, well, this is a secure area, so you need to leave the building right now.
I'm just reading these brochures.
Okay.
There's no filming over there?
This is a sign posted, and I handed you, actually about a week or two ago, I handed you a court order that prohibits filming in this area. So you've been informed of the administrative order, okay?
Well, I was just trying to read some brochures, so I'll go.
As you leave then.
Okay, thank you, thank you. Is this a public place?
This is the Justice Center.
Man, this doesn't seem very...
Sir, what area did we just see in the Justice Center on the video that the defendant, when he panned his hat or the camera?
That is our secured area right by the elevators and the information desk, the general vicinity of that area.
Again, within the prohibited area?
Yes.
The order, sir. I handed you the order.
It doesn't seem very public here.
That's right. You read the order.
And what are you doing right now, sir, on the
It's not
video?
us.
I'm just following him. He's walking out, and I'm basically just following him out.
We didn't make the law.
I know, but you enforce an unjust law, and that's what's so wrong about it. You guys are fucking assholes.
Does that end your encounter with the defendant on the 22nd day of September 2017?
It does.
Thank you, sir. No further questions for the witness at this time, Your Honor. 10 minutes.
Officer Polano, so you had the encounter with Mr. McGuire on August 25th, 2018?
2017.
17, I'm sorry. I've had to train myself to do 18, and so August 25th, 2017?
Yes.
At which time you believe that he was actually videotaping what was going on in the secured area?
It was in the afternoon after lunchtime, and I'm going to guess between 1, 2, 3 o'clock in the afternoon.
Exhibit 2, is that a fair and accurate depiction of your encounter with Mr. McGuire?
Yes.
Okay. And when you asked Mr. McGuire to leave, he left?
On the 25th, I didn't ask him to leave. He had left already when I started to approach him outside.
Okay.
My deputies asked him to leave,
Okay, and he left.
and he left.
On September 22nd, 2017, you had an encounter with Mr. McGuire?
Yes.
And when you approached Mr. McGuire and inquired as to what he was doing, he didn't volunteer any information that he was videotaping, but you surmised he was?
Correct.
And exhibit number 1 that's been admitted, does that fairly and accurately depict the totality of the encounter between you and Mr. McGuire?
Yes,
And you asked Mr. McGuire to leave,
I did.
and Mr. McGuire left.
Yes.
That floor is known as the ground floor in this particular building, is it not?
It is. Some people refer to as lobby, ground floor.
Okay. But there is a first floor.
Correct.
And are you familiar with this building, Mr. Pilato?
Yes, I am.
Yeah, probably much more than almost any of the rest of us. Have you been on the first floor?
I have.
And does the elevator exit on the first floor?
Yes.
Okay. And are you familiar with the area around the elevator?
Yes.
Okay. And is that a secured area?
Well, if you ask them, can they film there? Yes, they can film there if they want
Okay.
to.
And the scene that's depicted in the, let's call it the front half of the lobby, from the security where you go through the scanners to the front of the lobby where the doors are. You can see that area from the first floor if you look over the stem wall, is that correct?
You can.
Okay. And filming isn't prohibited from up there?
Filming is not permitted on the first floor. Filming of our security procedures on the ground floor, lobby if you want to call it, is prohibited.
Okay. I don't have any further questions. May I confer with my client? Certainly. I don't have any further questions. Thank you, officer.
Any redirect?
Just one question, sir. On the 22nd day,
Thank you, sir. Thank you. You may step down. You are excused from your speaking.
Speaking of that, Your Honor, no further witnesses.
Says the defense.
Your Honor, I don't know if you can get a judgment of acquittal on an order to show cause. I'm respectfully requesting that it appears by virtue of this very well-worded administrative order that the sanction for failure to comply with the rule will subject the person to immediate removal from the Justice Center. In the first case, my client left, and in the second case, when he was ordered to leave, he left.
Well, let me ask you this, Mr. Sherman. Do you have any authority that says, and I concede that the operative paragraph, the last paragraph, or the second to last paragraph of the addendum to the administrative order reads, failure to comply with this rule will subject the person to immediate removal from the Justice Center. Do you have any authority that says that in order to be held in indirect contempt, the person must be informed that his conduct could result in indirect contempt?
I don't have any case law either direction.
Okay.
So, it is our position, though, as I stated earlier, that the case cited by
I understand that case.
Mr. Patterson specifically informs the person that they could be held in indirect criminal contempt. So in that particular case, there's no due process argument. And he's held to know that. He's held to know the administrative order, whether he's been handed a copy or not. But in this particular case, there's nothing that places anybody on notice of sanctions that could include incarceration.
Solely as it relates to the issue of a judgment of acquittal, assuming that there is such a thing as a judgment of acquittal in order to show cause, and that's a high assumption, I don't even know if there is one, but to protect myself, assuming there is one, at this point it would be denied because I believe the state has presented sufficient evidence for a prima facie case.
Okay?
What says the defense regarding evidence or testimony?
May I have a moment?
Certainly.
Judge, we have no further evidence at this time.
All right. Give me 1 second.
Yeah, of course. We do have argument, though, Judge.
I understand.
Okay.
I'm reading.
I didn't want you to think that I was done.
No, I understand. I'm reading the evidence that was admitted. State argument?
I believe we have shown the defendant did commit indirect criminal contempt. He was provided a copy of the addendum that specifically prohibited recording in a specified area. He then returned it. He did, in fact, record in that specified area, so he was put on notice of what he could and could not do, where he could and could not do it. The evidence shows that he did do it. There's no dispute as to that. As to the lack of a penalty provision, Your Honor, we have not found any case law that says in an indirect criminal contempt case that that has to have been conveyed somehow to the defendant. The Schmitter case merely contained that. The Schmitter court did not say that it's an absolute requirement. For those reasons, I believe we have proven the defendant did commit indirect criminal contempt in violation of the addendum to Administrative Order 2.18.
Sure.
May I approach? Judge, I have two cases. I'll concede that neither one of them are exactly on point. I think the Schmitter case is clearly distinguishable. That there was a case where people were passing out jury nullification pamphlets, and the court focused more on the necessity of protecting or preserving the process, that by permitting persons associated with that particular organization to target prospective jurors was causing undue influence and perhaps improper instruction on the law. In the two cases I cited, one is Smith versus Cumming. Now I can see that's a 1983 action, federal action, and Mr. and Mrs. Smith, they didn't grant the relief because they didn't think the 1983 action was appropriate. But the language on the first page of that, I'm not going to read all of them. The court can read just as well as I can. But it resounds on language about the First Amendment. First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. The court has viewed this. It's quite obvious that Mr. McGuire was not videotaping this in order to orchestrate a security breach. He was doing this for what he felt to be in the public interest. It was published on a public website. There's more language with regard finding that an independent reporter has a protected right under the First Amendment, the state law to videotape meetings, finding the press generally has no right to information superior to that of the general public. It's case law after case law with regard to First Amendment. Now, the McDonough versus Fernandez-Rundle case, that was kind of an interesting case because they actually sought to prosecute that individual for audio taping a conversation between he and the police chief that occurred in an office of the police station. But I concede that a lot of the focus of that particular argument was on the fact that there was no expectation of privacy, but it was not explained the rules of the meeting between the individual and the police chief. If there were rules about no videotaping, in this particular case, there's a rule no videotaping, but what the sanctions were, there's no discussion about no audio taping and what the sanctions would be in case you audio tape it in the police chief's meeting. Not only that, but the police chief had other people there. In this particular case, it wouldn't apply anyways because there's no expectation of privacy, certainly not in the lobby and with all the other deputies there. So we wouldn't have to worry about that prosecution. But how the language in the McDonough-Fernandez-Rundle case we think is nevertheless persuasive. I understand it's with a courthouse, it's a different type of structure. It sounds like, in the case cited by the state, that they're considering it. I don't know. I don't know if they're trying to maintain the sanctity or they're trying to maintain the security. But if you notice, you don't have the same type of warnings, the same type of posted warnings, the same type of violations of the law. If Mr. McGuire would have done the same kind of thing walking through TSA at the airport. It seems kind of silly that they don't do it there, but they would do it here in the area downstairs. The final problem that I have with the order, the way it's worded, Judge, is, as Officer Pilato alluded to, now he said it's illegal to audio tape or to videotape in that area that is clearly posted, no videotaping. It says, at no time may any person display or use any electronic device while in the security screening area of the ground floor of the Justice Center. Yet, it seems to indicate that videotaping from the first floor while leaning over the stem wall would be permitted under this order. The order is vague. It doesn't cover all scenarios. It doesn't make sense that you can't videotape from the ground floor, but if you go up the elevator to the first floor, you can lean over and you can videotape. What Officer Pilato said his belief was does not pan out in this particular order. Respectfully, Your Honor, when Mr. McGuire was invited to leave, he left both times. He complied with the law. When they told him to go, he went. We do not feel he should be subjected to quasi-criminal sanctions for his conduct in this case.
State your vote.
Yes, Your Honor. Ms. Sorensen's going to handle the legal aspect.
Yes, ma'am.
Thank you, Your Honor. Your Honor, both defense counsel's case, Smith v. City of Cumming, along with McDonough v. Hernandez-Rundell, they're talking about public forums. Specifically, in the Schmitter v. State, it discusses how this is because courthouses and courthouse grounds, with the exclusion of the permanent public sidewalks, have uniformly been treated as non-public forums for purposes of the First Amendment. That's citing U.S. v. Grace, 461, U.S. 171. Also citing Humisky v. Corsones, 396, Federal 3rd, 53, Samaritano v. 1st Judicial District Court, 303, Federal 3rd, 959, Comfort v. McLaughlin, 473, Federal Supplement 2nd, 1026. Both of those cases that defense counsel is citing is discussing a public forum. Courthouses in themselves have been cited as non-public forums. Therefore, further down the page on Schmitter, it states, a non-public forum exists when publicly owned facilities have been dedicated to use for either communicative or non-communicative purposes, but have never been designated for indiscriminate, expressive activity by the general public. It continues to go down. A government's decision to restrict access to a non-public forum need not only be reasonable, it need not be the most reasonable or the only reasonable limitation. The reasonableness of the government's restriction of access to a non-public forum must be assessed in the light of the purpose of the forum and all the surrounding circumstances. The government is not required to choose the least restrictive alternative. It need only choose one that reasonably fulfills a legitimate and demonstrated need. In this case, Your Honor, the state's argument, the purpose of the amended administrative order is to protect the security of the courthouse. It's not saying you cannot record anywhere in the courthouse. It's saying you cannot record in a specific area. It is reasonable. In fact, in the state's other case that was provided earlier in the week, I do have copies for everyone. Knight v. Chief Judge of Florida's 12th Judicial Circuit, 2017, Florida Lexus 19790. This was a second district court decided a little over a month ago, in which the court ordered the Sheriff Knight of Sarasota to provide security for the courthouse, and the sheriff tried to argue that that was not appropriate. Clearly, the Second District Court of Appeals found that the security of the courthouse is well within the administrative judge's ability to make sure that the courthouse can perform its functions. Therefore, the security is well within the administrative judge along with the main judge to restrict certain access to those security issues. The whole purpose of the security, of not recording in a security zone, is similar to in any environment, such as any government agency, the airports, anything like that. They don't want someone to be able to record, find the weak points in a location for security and then be able to attack those weak points. It doesn't matter what Mr. McGuire's intent was. The purpose, he was recording in a restricted zone specifically for, that was restricted specifically for security reasons by the administrative order. Based off those reasons, we'd ask that you find the defendant in indirect contempt and sentence him accordingly.
All right, give me, I'm aware of Mr. Shirley's case law, so give me 5 minutes to read this case law. All right?
Court stands ready to go. Court's back in session.
Please be seated. Oh, sorry. Court finds as follows: following facts. That pursuant to the authority of the Chief Judge of the Supreme Court, pass along to the Chief Judge of the 20th Judicial Circuit, who may pass that authority on to the Administrative Judge of each county. That Administrative Order 2.18 and the addendum to 2.18, the addendum to the 20th Judicial Circuit Administrative Order 2.18, signed by Judge Alcindor on July 6, 2017, was procedurally valid as it was passed, pursuant to the authority given to the Chief Judge and passed along to the Administrative Judge of the county. The court further finds that on August 25th, 2017, Mr. McGuire entered the Charlotte County Courthouse, posted conspicuously on the doors and inside the interior security area of the courthouse. There are signs that prohibit, that designate that area as a secure area and prohibit recording of any type. That posting is in conformity with the addendum to the administrative order. On that date, on August 25th, 2017, Mr. McGuire entered the secure area of the Justice Center and using an electronic device did in fact film the secure area of the Charlotte County Justice Center and subsequently did post the filming on a public YouTube website, apparently called So They Call This Freedom. That posting, which has been admitted into evidence, demonstrates that Mr. McGuire did in fact film the entire secure area, including the magnetometers, the area in which law enforcement patrols and secures, and the area in which individuals enter and exit the Justice Center. It also demonstrates that Mr. McGuire was told that he could not film, was directed to the signs. He actually filmed those signs upon his exiting and was given a copy of the addendum to the administrative order by Deputy Pilato. The court also finds that subsequently on September 22nd, 2017, Mr. McGuire entered the Justice Center and passed through the secure area to the information desk. The information desk is still part of the secure area. That is very conspicuous. There's a giant metal bald eagle that has been there for decades. A sculpture by Attorney Schwartz, dedicated, given to the county. He then turns from that area and specifically points his camera at the secure area, filming the magnetometer, the law enforcement officers there, as they are executing their procedures. At that time, Deputy Pilato again walks up to the defendant, asks the defendant if he is filming. Mr. McGuire does not answer, which is his right at that time. Deputy Pilato then, believing that Mr. McGuire's activity was consistent with somebody who was filming, based on the testimony of Deputy Pilato, that Mr. McGuire had a camera attached to his hat, and Deputy Pilato requested that Mr. McGuire leave the Justice Center. Mr. McGuire did, in fact, then leave the Justice Center. Additionally, this did, in fact, occur. There is no doubt that this occurred. Similarly to the August 25th incident, the September 22nd incident was, in fact, filmed, and it was, again, posted on a YouTube site called So They Call This Freedom. Thus, the evidence is, in fact, that Mr. McGuire entered the Justice Center, filmed the secure area of the Justice Center on 2 occasions, was told he could not film the Justice Center, recorded the signs regarding that this is a secure area and he was prohibited from filming in that area, and then posted the filming of the secure area on a public website. So, that is the factual issues in which the facts that the court finds that are operative in this case. There are several issues in this case. Some of them constitutional issues, so I'm going to go through them. First issue is, has the state demonstrated that Mr. McGuire is in violation of the addendum to Administrative Order 2.18 and therefore in direct criminal contempt? The evidence is clearly beyond a reasonable doubt that Mr. McGuire had notice of the prohibition of filming in that area and that he did film in that area. The issue is whether this order is such, or strike that his conduct was such that it infringes or impedes the fair administration of justice. Courts have uniformly indicated that judges, chief judges, Supreme Court judges, have the ability to control within reasonable degree what occurs in their courthouse and courtrooms for the fair administration of justice. The state cites Schmeder, S-C-H-M-I-D-T-E-R, versus State 103 Southern 3rd 263. At least as it relates to the issue of whether courts can pass such rules. And this is actually, in the opinion, kind of as it relates to First Amendment issue, but it is applicable at this stage also. Clearly, the security of the Justice Center is well within and absolutely essential to the fair administration of justice. Without a secure building, there can be no fair administration of justice. Part of that security, and the state, Ms. Sorensen properly articulated, is that especially in this day and age, security measures of any government building are clearly subject to being protected. With the dangers of modern society, dangers inherent in having those security issues become public, or security measures become public, it then becomes easier for individuals with nefarious intent to circumvent those security issues. Thus, at its core, there can be no greater component of the fair administration of justice than the security of the building, and prohibiting individuals, groups of individuals, or the general public from having knowledge, or potentially having knowledge, of the security parameters of this building. Therefore, based on that, the court finds that, in fact, that the administrative order is, or the addendum to the administrative order is narrowly tailored to protect that specific administration of justice, and that the defendant, by filming and publishing for the public to view the security protocols of the Justice Center, that in fact he did hinder the fair administration of justice. Does that mean that Mr. McGuire is in indirect criminal contempt? Mr. McGuire has raised several defenses. These defenses, yes, the court will shorten them to vagueness, overbreadth, and a First Amendment defense. So let me take each of those in turn. As it relates to the vagueness argument, typically we deal with vagueness as it relates to statutory construction, in that a statute is vague if it does not put a normal person, a person of normal, reasonable person, on notice of what is the prohibited conduct. And therefore, the person, it is impossible for that person to know or reasonably know the conduct that is prohibited and conform his or her conduct accordingly. That's the overarching meta view of vagueness. Certainly that would apply to this administrative order, because the defendant is subject to incarceration, and thus, if the order is vague, he should not be held in contempt. This order is not vague. It is, in fact, very specific. The addendum specifically defines electronic devices. It specifically defines the security screening area of the ground floor of the Justice Center. It says the entire area open to the public from the ground floor exterior entrance doors through and including the area adjacent to the elevators, and the area beyond the elevators in the vicinity of the information desk, and the entrance to the maintenance area, the stairwell, entrance, and law library. It then goes on. It specifically talks about issues relating to electronic devices in courtrooms, subjecting people to immediate security screenings, and then it says, at no time may any person display or use any electronic device while in the security screening area of the ground floor of the Justice Center. That actually could not be any more cogent and precise. So the issue regarding vagueness is not there. the administrative order is not vague. In fact, it is specific and would give notice to a reasonable individual of the prohibited conduct and thus allow that individual to conform their conduct in accord with the order. As it relates to, I guess, overbreadth, the argument is that perhaps because the order doesn't include the loft area, the half wall area on the first floor, somebody could simply go up there and look down at the security area and film it. Mr. Shirley is correct. Somebody, according to the order, somebody could do that. That doesn't mean that the order is vague or overbreadth or is some defense for the indirect criminal contempt, because that's not what occurred here. Mr. McGuire was not on the first floor over the half wall filming the security area. He was in the specific security screening area of the ground floor of the Justice Center. All that shows is that the order is not fantastically written, and I suggest will probably be amended again. Mr. Shirley then argues that in the last sentence of the second to last paragraph of the addendum, that it says, failure to comply with this rule will subject the person to immediate removal from the Justice Center. This is an interesting argument. Mr. Shirley argues that, I guess, reading between the lines are two arguments as it relates to that sentence. One, that Mr. McGuire is not placed on notice as to what the penalty for his violation of the court order could be, and two, that sentence is a limit of the penalty that could be imposed. The court has asked either party to provide any authority that requires an individual to be given actual notice of what the penalties for indirect criminal contempt could be, and I have done some research, and I have found none. It appears that there is no notice requirement insofar as what the penalty for indirect criminal contempt could be. The penalties for indirect criminal contempt are well stated in the law and outlined in the law, and the penalties are what the penalties are. This court does not, additionally, this court does not read that sentence, failure to comply with this rule will subject the person to immediate removal from the Justice Center, as a assertion by the administrative judge, Judge Allison Droney, of the penalties for violating this addendum. Rather, when this addendum in its entirety is read in conformity with the administrative order, rather this sentence appears to be the administrative judge granting the Sheriff's Department the authority to remove individuals from the Justice Center, rather than a boxing in of what the penalties could be for involuntary or for indirect contempt. So, having disposed with that issue, the court now goes on to the First Amendment issue. And it's an interesting issue, and one that shouldn't be taken lightly. It's interesting. Society has changed. No longer do we view the days of Walter Cronkite on the 6 o'clock news and that being the only news organization are long gone. In fact, studies indicate that most millennials do not get their news from what us old people view as traditional news sources. Newspapers are a dying breed. The network 6 o'clock news hours are dying. The local news hours are dying. Research shows that most millennials get their news online, including sources like YouTube. It is not this court's desire, nor is it appropriate for this court to engage in some content-based assertion of what is a valid news source and what is not a valid news source. That would be totally impermissible. As we all know and sit here, the First Amendment protections are content neutral. We are in an age where almost every single person is their own news agency. Whether that's good, bad, or indifferent, I don't know. But that is the truth. So, going through the First Amendment issue, jotted some notes down. The general overall principle is restrictions on First Amendment rights must be supported by compelling government interest and must be narrowly drawn to ensure that there is no more infringement upon that right that is necessary. The issue of, there are two issues here. Public space versus non-public space, and public speech versus non-public speech. And they are different. Ms. Sorensen has adequately and thoroughly set out the difference between a non-public space and a public space. Public speech are matters of public concern. And those are at the heart of First Amendment protection. That is why the First Amendment was passed. We want matters of public concern to be in the open air and in the rhetorical course of commerce. And by that I mean the founders wanted everything out there. And let the people decide what has merit and what does not have merit. And the theory behind rhetorical commerce is that those ideas that are bad, do not have merit, are salacious, are racist, derogatory, offensive, will be rejected. And they will go by the wayside. And those ideas that have merit will continue to flourish. It's been said that expressions on public issues have always rested on the highest rung of the hierarchy of First Amendment values. Public speech has been defined as speech that deals with matters of public concern, when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of legitimate news interest that is a subject of general interest and of value and concern to the public. That's Snyder v. Phelps, 562 U.S. 443, 131 Supreme Court 1207, United States Supreme Court 2011. In Neptune v. Lanois, 178 Southern 3rd, 520, 4th District Court of Appeals, 2015. This is an interesting case. This was a case involving filming of a police officer. And the police officer actually, there was individuals from a YouTube channel that viewed themselves as citizen reporters. They believed that there was corruption in the police force and they were filming police officers. And the police officer filed for a stalking injunction against the people that were filming them. And the court rejected that. And the Neptune court said, the court noted specifically, quote, obviously, alleged misconduct by police officers is a matter of general interest and of value and concern to the public. So, There is no doubt that the First Amendment protects an individual's right to criticize its government. In fact, that is the core of the First Amendment. And it is the cornerstone of this republic. And it is what makes this republic different from every place else. And it is important to note that that right flows as a result of an individual drawing breath. That is different from every other form of government ever in existence. Every other form of government ever in existence, the king, the sovereign, gave rights to the individuals. Our founding fathers rejected that and said, no, we have basic rights because we walk this earth. In our form of government, our state constitutions, our federal constitution, they are documents of limiting power. We, the people, we grant the government power. They have only the power we give them. There's a portion of the Constitution that seems to be ignored often, and that is that those powers not expressly stated are reserved, right? They're reserved. On the federal government, they're reserved to the states. The state has those powers. The United States Supreme Court has said the freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. That's City of Houston v. Hill, 482 U.S. 451, at page 462, 107 Supreme Court, 2502, 96 Lawyer Edition, 2nd, 398 United States Supreme Court, 1987. But as we know, there is always a however. No right is absolute. In fact, we can go back to the political philosophers upon which our founding fathers wrote our governing documents and read the discussions about absolute rights and restrictions on rights. And Jefferson himself talked about rights not being absolute. Correct? We all know that. You can't yell fire in a crowded theater. It has been changed to a crowded movie theater, but the original was a crowded theater. And it is an old statement. So, restrictions on First Amendment rights must be supported by a compelling government interest and must be narrowly drawn to ensure that there is no more infringement than is necessary. Just for the record, the court is undergoing a strict scrutiny analysis of the First Amendment. I don't know if that actually applies. A lesser standard may actually apply in this case, but I'm going to give the defendant due deference and analyze this under the highest protection afforded to Mr. McGuire. The court's theory is that if the decision based on the highest theory, only the state could be offended if I rule against the state. There's no doubt that the state has a legitimate interest in protecting the judicial system and the fair administration of justice. That's Schmitter v. State, 103, Southern 3rd, 263, 5th District Court of Appeals, 2012. And in that they cite the United States Supreme Court decision in Cox v. Louisiana, 379 U.S. 559, United States Supreme Court, 1965. The state has asserted or argued that the compelling government interest is to ensure the protection and security of the courthouse and all those who enter and use the courthouse. That this security issue, that protecting the security, matters of the courthouse is inextricably intertwined and linked to the fair administration of justice. And I agree. As I previously said, One of the court's responsibility is to provide for the orderly administration of justice. The safety of all who enter the courthouse is an indispensable component of the orderly administration of justice. This administrative order, or more precisely the addendum to the administrative order, one the court notes is content neutral. That's important to note. There is no specific assertion regarding specific individuals or specific viewpoints. It is content neutral. The addendum also describes with specificity the security screening area of the ground floor of the Justice Center. Order goes on to state, at no time may any person display or use any electronic device while in the security screening area of the ground floor of the Justice Center. Thus, the government has demonstrated a compelling state interest. The infringement upon the First Amendment is narrowly tailored in this respect to achieve that compelling state interest. It is done with specificity, and it is content neutral. Therefore, the court finds that if there is any infringement upon the defendant's First Amendment, Mr. McGuire's First Amendment right is constitutional, even under the highest scrutiny, that being a strict scrutiny. Look, the reality is that there are valid security issues. Filming those place those security issues in jeopardy, and by doing so, place every individual who comes into this courthouse to use this courthouse at risk. Certainly you can't go up to, say, the nuclear submarine base in Bremerton and start filming inside their walls. You cannot. There are issues in which there are compelling government interests. And the court notes that, with the exception, I think, of one other area, Mr. McGuire is free to film at other areas within the courthouse. So, based on that analysis, the court finds that the defendant is guilty of indirect criminal contempt. Mr. Sherwood, any mitigating evidence or argument you would like to make on behalf of Mr. McGuire?
Your Honor, the purpose and intent of Mr. McGuire's filming, Mr. McGuire does not agree with many of the policies and procedures of the Charlotte County Sheriff's Department. And over time, he has made several public information filmings. He's not very popular with the fellows downstairs, and he films things downstairs, and I'm not going to argue with the court, albeit under this circumstance improperly, in an abundance of caution because of some of the treatment he has received over time. If the court is thinking about incarceration as a potential sanction, I would ask that the court consider delaying that sentence. Mr. McGuire has other matters before the court that are scheduled February 9th.
I believe so.
And we would like to resolve all of those at the same time. If the court is going to seek out a non-incarcerative sanction, then we're prepared to go forward.
All right. Anything else on behalf of the defense?
No, sir. Well, one thing, Judge, I don't want the court to think that he was doing this to place anybody, whether it be the public or the ladies and gentlemen of the Sheriff's Department, in any danger. It wasn't to disseminate information about their scanning devices or anything else. He's been a very, very strong proponent of the Bill of Rights, as shown by his website. Maybe some things he's a little misdirected on, but nevertheless, it's his right to voice his opinion on those matters, and he has done so over time. So it wasn't with the design to create any type of security breach or anything like that. It was designed to more adequately inform the public as to what goes on downstairs. I get treated very well downstairs. Mr. McGuire may not. I don't know. I'm not there when he goes through downstairs. Nevertheless, obviously, from this point forward, Mr. McGuire is going to have to find another avenue to build a case for his public forum other than filming downstairs.
This is a statement.
We would be seeking a period of incarceration of whatever length you could draw in terms is just and fair. This is just an absolute blatant disregard for the administrative order, for the court, for the fair administration of justice. While he has a right to film what he wants and post what he wants, he also has an obligation as a citizen or at least a person in this country to follow the laws as he's instructed. He was instructed on the law. He was told not to record in a specific area, and he comes back and he blatantly gives the finger to that order and goes ahead and does it again. As Your Honor pointed out, there are many other areas that can be recorded in this courthouse, thousands of square feet, and yet he comes back and does the very thing that he was told not to do, all in an effort, State would argue, just to get into a fight, to provoke a reaction from law enforcement for his own benefit. The defendant, he says he follows the Bill of Rights. The defendant picks and chooses what he wants to follow. But as a member of the society, he too has an obligation to follow the law as he's been instructed. He was instructed plain as day not to do it, and he came back within a month and did it right again. So we would seek a period of incarceration, Your Honor.
All right. First of all, a couple things. From viewing the video, I do want to say that I commend Corporal Pilato on how he handled the situation. And just on the part of the video I saw, he was firm but polite, exercised his discretion in a professional manner. For the record, just so we know, Deputy Pilato, you are what, 6'6"? I'm 6'5". Deputy Pilato is a large individual. I think he showed great restraint. He enforced the order of the court and did so in a professional manner. Also want to state for the record that, at least out of the video that I saw, Mr. McGuire conformed his conduct to Deputy Pilato's request. Deputy Pilato said leave, Mr. McGuire left. I think in one of the dates he gave a exiting FU, which is his right. There's a case right on point. When I was at the state attorney's office, I used to call it the FU cop case. Cops have to have thick skin. You get told FU a lot. But we're not here on whether Mr. McGuire's view of the Constitution is right, valid, misguided, whether he's a strict contextualist like Scalia, or whether he is a modern interpretist like Ginsburg. We're not here for that. We're here, and I am going to sentence Mr. McGuire according to what I believe was depicted in the evidence here. It may be true that in other situations Mr. McGuire has been a total jerk to law enforcement. It may be true. It may be even well established or known throughout the community. Who knows? But that's not in front of me, and I'm not going to rule on that. That would be unfair to him. I think given what I saw in the video, an incarcerated sentence would be unfair. I'm going to adjudicate Mr. McGuire guilty of indirect criminal contempt. I'm going to fine Mr. McGuire an amount that equates to, generally speaking, what would be a cost of court and cost of prosecution. So in this case, he will be fined a total of $385. He will have to pay. How long does your client need to pay that fine?
Can you do community service in order to work that out?
Yes. However, in this case, I will only allow Mr. McGuire to do community service.
For half of it?
No.
Oh, I'm sorry.
At a community service place that is authorized either by state probation or county probation.
I'll give him the list.
I have granted Mr. McGuire some leeway on other cases. In this case, because it is direct violation of a court order, I'm not going to allow him to do that. Okay? Additionally, within the next 20 days, Mr. McGuire will remove from all public forums any video that depicts the security area of the Charlotte County Justice Center. So if it is on YouTube or whatever, he has to take it down.
Judge, he will volunteer, well, in compliance with the order, but he'll remove it from any website that he has access to that he can control the dissemination of that information.
All right. So are we saying that he may not be in control of websites that has been disseminated to?
His concern is that there may be other websites that have copied it and have put it on their own websites. You know, if we and so
I understand.
These folks aren't party to this and can't control their conduct. But we'll get rid of everything off of his website.
All right. The court will also, for the record, indicate that Mr. McGuire is being admonished of the rules. These rules are not vague. But there is a reason for these rules. I agree with Mr. Shirley. I don't think there was any nefarious intent on behalf of Mr. McGuire. In that, I don't think he was going in trying to film security procedures in order to affect a breach or inform some radical group of how to breach the security of the Justice Center. However, there are unintended consequences. Somebody with ill will, malice, or a nefarious idea could use what you filmed to tragic consequences. So, you have been warned, sir. You have been warned by the deputy. You've been warned by this court. This court warning you of this order is now a matter of record. I suggest you conform your conduct to that. If you do not, you are likely to be sitting there again. And you may not be in front of a judge that views the First Amendment the way I do. It is the reason I spent so much time going through the First Amendment, because I do believe that the First Amendment is the cornerstone of our republic. Anything else on behalf of the defense?
No, Your Honor, thank you.
On behalf of the state?
No, Your Honor.
Hold on 1 second. Did I get everything?
Yeah, but how long does he have to do all that?
Oh, yeah.
You asked.
I did ask. How long does he need to do community service? I never got an answer. At the rate of $10 an hour.
You have to do it probation.
Oh, so
Like 60 days.
60 days. So granted. I think there is an appellate right on this. If not, I want to inform you of one. You have 30 days to appeal the judgment and sentence of the court. Can't afford an attorney. Actually, it's not. You're not entitled to a court-appointed attorney, but you have 30 days to file an appeal. Do it as a fine.
County, this is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Charlotte County COPWATCH with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me and I'm sick of it, so I'm trying to wake people up. But my wife would love it if if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave let's say actually yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is, if I got some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head, help out. This is a lot of work every single day. Thanks.